We appreciate you being here. Elizabeth is an attorney out of the Los Angeles area with Clark Howell, and you're going to be talking on a variety of issues and current events within the cannabis industry. So we are going to turn it over to you.
Absolutely. And if you'll just give me a moment, I will set up my slide deck and share my screen. Bear with me for one moment.
We see your screen.
There we go. Yeah, it's been one of those things. It seems for some reason that every time we've been doing this, except for the very, very first one, we have had one issue after another with electronics. It's almost like things don't, like, it's not supposed to happen. In fact, here's a crazy one. I was
we see it.
uploading videos yesterday and into Dropbox. And my last video that was to upload was our special surprise guest that we had. And all of a sudden, I couldn't use Dropbox. I couldn't even log into Dropbox anymore. It just kept downloading a text page. However, today, I can get in there. What changed overnight? Who knows? Craziness.
I know, it's a brave new world. Okay, thank you everyone for being patient with me. I've gotten my slide deck up and running. So my name is Barket Kremser. I'm a regulatory attorney with Clark Howell. Clark Howell is a women-owned law firm serving hemp and cannabis clients throughout California. I work in the regulatory group, so I help our clients with licensing matters, supply chain contracts, general compliance issues, and policy advocacy. And interesting that Keith is also from the telecom industry before he, pivoted toward his interest in cannabis. I used to work for a telecom trade group in DC representing nationwide and regional carriers before the FCC. So always good to see that unexpected crossovers between telecom and cannabis. So today I'm going to talk about the industry writ large. So I'm going to step back and take more of a nationwide view using lots of examples from my home jurisdiction, California. So we'll talk about the status of the industry, hot topics in cannabis, social equity programs. I give a few highlights from hemp if there's time, and then move on to Q&A. So let's step back and see, where we're at in the United States with legalization. So federally speaking, cannabis is still a Schedule I drug, federally illegal under the Controlled Substances Act, but we see this patchwork of varying statuses of legalization and decriminalization throughout the United States. Where I'm at in California, we've enjoyed some level of legalization dating back to the late 90s, and since 2017, we have MCRSA, which regulates a medicinal and adult use marketplace. And of course, this is changing all the time. This map is from 2020, but we know, especially, in light of COVID, many states and local jurisdictions are looking to cannabis as a revenue source and a jobs provider. So let's look, at that data a little bit more closely. It's really interesting for me as an attorney, stuck in the minutia to see exactly how the status of the industry is being presented in the press. And here, we see the upwards trajectory. Cannabis, in 2024 projected to make over $100 billion. Cannabis in 2024 growing to a jobs provider topping 500,000. We see evolving consumer research. Research from this year indicates that, more and more consumers look to cannabis for medical or wellness reasons, and 19% don't draw any distinction between medical use and recreational use. There's still a lot of gaps in consumer understanding, but this is a pretty profound change in the way that cannabis is perceived. COVID has also had an influence on that. So when, after COVID-19, really rose to the national consciousness in March of this year, cannabis became part of the essential infrastructure. So, this is a big step for consumers who were afraid of losing access to their supply during COVID, and also the industry. Because, when you're part of the essential infrastructure, of course, you can stay open, but it's really a new legal status. So, as attorneys, we saw our clients grappling with new responsibilities and new compliance concerns. Of course, the cannabis industry is very heavily regulated, sometimes so much so that it's easy to lose sight of all the other regulations that apply. And, COVID certainly drew attention to the health and safety rules that apply to working or operating a cannabis business. New employment law issues came up. Of course, bud tenders went from, customer service employees to, part of the essential infrastructure. Operators were looking at, changes in their workplace operations, sometimes even, employment reduction. So employment law became important, as well as the sufficiency of the supply chain. So, we were reviewing contracts, making sure that, the contractual rights of our clients were not going to be affected, due to any disruptions in the supply chain. And there was also a push for advocacy at the state and local level. So really, in California, the whole industry banded together to push for clear freedom to operate for both medicinal and adult use cannabis operators. And at the state, this happened relatively quickly. At the local level, there were some significant challenges. Some local jurisdictions don't understand the difference between medical and adult use. So, there's a lot of advocacy and, pardon me for 1 second. Are you all able to see the presentation?
Okay.
No, I'm just seeing you.
You're up again. So I have you spotlighted here. And if you can just reshare your screen again, please, that would be awesome. Thank you.
Sure.
So much.
I apologize.
No, that's all right. We just don't want to do any screen sharing from anybody.
No problem. Let me just...
Unless it's the presenter. So Elizabeth, if you just kindly share your screen again, that would be super duper awesome.
Give me 1 moment. I apologize. I'm having an issue navigating back to Zoom.
You got it, Elizabeth?
1 second. Something wonky is going on with my technology. I truly apologize.
Oh, like I was saying, I literally had no Dropbox. It was gone last night. Literally gone. I tried uploading from different computers. I tried even uploading from my phone last night and nothing. I couldn't get anything to upload. Of course, it was a special video from special Dr. J that we might know could be a little bit controversial, and nothing today. However, I ended up going to a different browser. I used Brave for that, and it finally managed to bypass everything. However, everything's working again today. It's craziness. Craziness. By the way, while I'm speaking, Dale, I know you can hear me. You need to share that really, really, really cool story that you put out about the crystals today, because that just makes me want to cry thinking about it. We have some really Tasha Jackson, she's the editor, oh, there you go, of Natural Awakenings magazine. I mean, we've got, and Big Al's here, you've got Dr. Anton, the White House doc. I mean, we've got some, Matt's woo is as woo as a lot of us and stuff. So Dr. Ted, he's going to get it. We're all going to totally love this story. So please be sure to share it. Thank you.
And I am recovering shortly, so apologize for that delay.
Are you ready, Elizabeth?
Yes.
Okay, great. I'm going to hand it on back to you.
All right. I'm just going to share my screen. All right. Can everyone see it? Okay. I'm just going to continue. I think I'm screen sharing. Please let me know if you're having any issues seeing the presentation. So I think where we left off, I was talking about the new legal status for cannabis operators under stay-at-home orders in California for essential infrastructure. So in short, there were some struggles, but cannabis was able to continue operations in the supply chain and create new opportunities for visibility in the industry and access for consumers. But significant hurdles remain, and we've talked about a few of those on this call. So access to banking and traditional financing is not available for cannabis operators. There's some serious issues in the way that cannabis operators are taxed at the state, local, and federal level. There are certain barriers that prevent, widespread branding and advertising campaigns that a company would normally undertake. And one of those things is federal trademark protection, as well as the onerous advertising rules for cannabis companies. And then, of course, there's always the lingering risk of federal prosecution. There's a lot of risk, to operating a cannabis business, but typically as attorneys, while we make those risks abundantly clear, we understand that federal enforcement is something of, maybe more of an ambient risk as compared to just making sure that you're compliant under state laws. But, this year we've seen a lot of tension between federal and state authorities. So in July 2020, the House adopted the latest version of something called the Rohrabacher-Farr Amendment. So, this is just the House version that was adopted. It has not been adopted into law, but the Rohrabacher-Farr Amendment is an appropriations rider that's adopted every year. And since 2014, it has prevented the DOJ from allocating federal funds to prosecute. It operates to prevent prosecution of cannabis operators that are in strict compliance with their state medical laws. Last year was the first year that the House adopted a version with language protecting both the medical and adult use market. Last year, that language didn't pass. So this year they're trying again. It's not expected to pass this year, but we are expecting there to be finalized language protecting medical only operations consistent with past language. So this definitely shows a continued tension, and technically speaking, there's not a lot of federal protection for an adult use operator. There's also litigation between the DEA and the Bureau of Cannabis Control, and that's California's lead cannabis regulator. So right now, the two agencies are in court, and the BCC is resisting a DEA subpoena for unredacted shipping manifests and cannabis license applications for 3 licensed businesses from Southern California. And so the BCC is arguing that the DEA did not specify, as it is required to do, clearly enough how the subpoenaed information relates to the DEA's investigation. I won't comment on the technicalities of the argument, but it's just remarkable to see these two parties in conflict. Usually you would expect to see these agencies working together. Another blow at the federal level, cannabis legalization was not voted to the Democratic Party platform, which some thought it might be. But the Democratic vice presidential candidate is the sponsor of the MORE Act, which is draft law that would federally deschedule cannabis, expunge records of those previous cannabis convictions, and start creating a national cannabis tax infrastructure. So, perhaps that is a positive step towards legalization at the federal level. There's also continued tension between state governments and local authorities. So right now, the BCC, California's leading cannabis regulator, is litigating against a coalition of California cities and counties. So California, a very important cannabis economy, of course, lots of support at the state level, not much support at the local level when you look at the totality of licensing jurisdictions that are there. So, in this particular case that went to trial earlier this month, the question to be resolved is whether the BCC overstepped its authority by adopting a rule, a regulation, allowing cannabis retail deliveries to any jurisdiction in California. So that means that if you're licensed in San Francisco, you can make a retail delivery to a customer in Oakland, provided you follow all the other rules. So that's the rule that's in question. And what's interesting is the cities and counties that make up, that coalition of litigants. Some of them are prohibition jurisdictions, so they don't want commercial cannabis activity taking place in their jurisdictions. Some of them are trying to protect their local cannabis economies. They want the business in their county or city to go to the licensee that is licensed by that jurisdiction. So that's something that we are certainly watching. Will be very important for our clients and other operators. Zooming out to some of the litigation trends, federally and on a more overarching level, there has been a rise in TCPA litigation against cannabis operators. So that's the Telephone Consumer Protection Act. This is a federal law. It's an anti-robocall, anti-robotext law that requires the implementation of certain consent and opt-out mechanisms when you are sending those automated communications. So this law is famously a target for the plaintiff's bar. The rules are very difficult to implement, and it's very easy to rack up significant penalties under this law. So, many cannabis operators, eager to avoid some of the strictures in cannabis advertising, are maintaining customer loyalty programs via text. So, the amount of lawsuits against the cannabis industry, is sizable, more than a dozen in May and June of this year. Targeting dispensaries and other companies in Oregon, Denver, Nevada, Florida, Arizona, and California, with the majority of the cases being brought here. So if you are using automated messaging over text or telephone as part of your advertising, this is a good time to review to make sure that you're compliant. There was also an SEC investor fraud suit in California this year, brought against 6 individual defendants that had raised funds from more than 400 individuals to support a cannabis farm in Northern California and a CBD extraction facility. So according to the SEC's filings, those investors those defendants misled their investors with guaranteed annual return on investment of 100% or more. Indeed, they never registered the securities. And the SEC is seeking permanent injunctions, disgorgement of ill-gotten gains, and civil penalties. So, this is obviously an extreme case of what sounds like some very unscrupulous actors, but it does reflect an upward trend we're seeing in distressed assets and partnership disputes in the wake of the green rush, where many people eager to become first movers in the industry made riskier investments. So a lot of these conflicts aren't playing out in a court of law. most cannabis transactions are relegated to arbitration or mediation or even receivership, since cannabis companies do not have bankruptcy protection. But we are seeing an uptick in these kinds of disputes. So it's also important to talk about social equity programming and how those programs are doing in the United States. So for those who are not familiar or tuning in from abroad, social equity programs attempt to establish cannabis policies that restore and repair communities most impacted by ongoing cannabis criminalization and the war on drugs. So these are very important programs in the community, but many states, when they implement their cannabis programs, don't take social equity into account. And the ones that do have experienced significant challenges in making those programs effective. So today I wanted to zoom in on LA's social equity program, which I believe has taken historic steps recently to support applicants and to remedy some of the issues caused by the program in its original implementation. So in the city of Los Angeles, there have been 3 licensing phases. There was the first phase of licenses, both retail and supply side, issued to legacy operators who had previously registered with the city. The next phase of licensing was for supply side operators that had historically supported dispensaries in the city. The third round of licensing was for storefront retail for those that qualified for the city's social equity program. And there was significant delays in this program, significant confusion about how the rules would be implemented. And in the licensing round, which was conducted on a first-come, first-served basis, there was an issue when certain applicants were found to have accessed the application submission system before other applicants. And so there was a question of whether the process had been compromised to the point where it would, licenses would not be able to be issued to those social equity applicants. And to be clear, only social equity applicants were eligible for this round of licensing. So that has since been resolved in a policy context. So those, initial 100 applicants that were in first will be able to proceed, but the city of Los Angeles and its cannabis regulator, the DCR, they completely overhauled the cannabis licensing ordinance, largely to improve the social equity program. So the biggest takeaway from these changes, they implemented new rules so that in the city of Los Angeles, new retail licenses for both storefront and delivery are only available to social equity applicants until January 1st, 2025. So this is an attempt to remedy some of the issues that happened earlier in the program and really get these applicants a chance to establish themselves in the Los Angeles market. Another big change they made was the definition of equity share. So, lots of social equity individual applicants that qualify for the program, partner with investors, but they must retain a certain level of equity in the company. And now under these new rules, a certain degree of control. So if you're a tier 1 equity applicant, you must retain 51% of control of the company. Tier 2 is 33%. But there's a new provision. It's a concept of unconditional ownership. So that means not only do you technically own the securities, but you have to exercise a high degree of control over the operations of the company. So, you have to have certain voting rights and control. You must be involved in all business decisions, including daily business operations. And the social equity individual applicant must have the highest officer position. So, of course, translating these policies and rules into the actual documents that will form the foundation of your business, that's where the devil's in the details and the challenge for the lawyers. But this all went into effect very recently. The new rules went into effect on July 10th. So the LA cannabis industry is still adopting and trying to understand how these rules will be implemented. And then I was going to go into some federal hemp news, but I know there was a delay in the presentation. I want to be respectful of the time of the other presenters. Is there room for a few more slides, or should we cut things off now? Now that we're at 10:28 for Q&A?
You know what? Go ahead, keep going, because this information is current and everybody needs to know.
Okay. All right. I've just got a few more slides, shifting gears to hemp. So a lot of the action going on in hemp is at the FDA level and federal enforcement. So I just wanted to briefly overview, how, who is regulating the hemp supply chain? Like, what is going on right now? So right now, for cultivators, they are regulated by the USDA. They are, under the Farm Bill, the leading federal regulator. Right now, hemp cultivators can either operate under the USDA rules, or a state or tribe can get a hemp cultivation plan approved by the USDA. And if that happens, the state or tribe will retain primary authority over hemp cultivation activity in the state. So some important deadlines coming up. After October 31st, the USDA's rules will control unless the state or tribe does have a USDA-approved hemp plan in place. So states that have hesitated or have not yet submitted a plan for USDA approval, such as California and Colorado, are staring down an interesting deadline coming up pretty quick. Manufacturing is not necessarily regulated at the federal level in terms of a hemp-specific regulator. So, this is a gray area. Companies that are manufacturing hemp products continue to operate in the gray area. The market simply expanded too fast for federal regulators. Some states do have hemp-specific manufacturing rules and regulations, like the state of Colorado. So right now, this is really the purview of the states. So hemp-derived CBD products are regulated by the FDA. And I think, as we all know, under the Federal Food, Drug, and Cosmetics Act, neither THC nor CBD products can be sold as a dietary supplement or added to food for humans or animals, and they cannot be marketed as a drug. And so, just to get a little bit more into the legal architecture of why this is the way it is at the federal level, it's because both CBD and THC are listed as active ingredients in approved drug products, and the exceptions to rules that would otherwise allow them to go into food and dietary supplements do not apply. So in order to get around this, the FDA would have to issue discretionary regulations approving its use. And there's a lot of tension here because we can all go to the store and buy hemp CBD products right now. This is a huge industry making significant strides, and the FDA is just trying to catch up. So how are they trying to catch up? We're not exactly sure. They will either have to, create regulations to regulate these products, or they'll have to seek a legislative solution to move a little bit quicker. But in March of this year, they reopened the public docket for submission of scientific CBD data. So, they are expanding their data gathering efforts to understand the potential effect of sustained and or cumulative use of CBD. So hopefully, it will be the predecessor to a real rulemaking proceeding that will give the industry a little bit more certainty about how, what products it can make and how. On July 22nd, the FDA sent over for OMB approval a draft enforcement policy. And this draft is not yet public, but, some of the FDA's past statements and announcements, indicate what might be touched on in this enforcement policy. So, some of the FDA's top concerns about CBD products in the market are, therapeutic claims. So claims about, what CBD can do as a treatment for cancer or Alzheimer's or, any medical condition. Those are the FDA plans to, police those most likely. And we think they may prioritize enforcement against quote, incorrect statements about CBD content. And this has been a big issue in the courts. So again, the plaintiff's bar has been bringing class action lawsuits against CBD companies. It looks like the plaintiffs, will purchase products, they will test them, they will compare the results of that testing data with what is appearing on the label of the CBD product. And, if it doesn't match up, that can form, the basis for a complaint, among other things. So, plaintiffs are also coming to the court saying that, they would not have purchased this product if the marketing hadn't implied that it was legal to sell under federal law. And the courts are really struggling with how to handle these complaints. And many of them are staying the lawsuits under something called primary jurisdiction doctrine. So there is a test for this, but essentially what it means is that the FDA is the lead regulator exercising authority over this field. They have not issued any guidance, so the court is going to stay these suits pending a clearer direction from the FDA. And again, this doesn't happen in every case, but it's an upward trend that we're seeing. And then, of course, in the meanwhile, hemp CBD enforcement continues, from federal regulators. So in 2019, there was a spate of letters from the FDA and FTC, warning letters to CBD hemp companies advertising the therapeutic effects of their product. In 2020, there was joint FDA and FTC enforcement related to COVID health claims from CBD hemp companies. And in fact, the FTC brought their, the first lawsuit that they brought against a company for making COVID-19 related health claims was actually against a CBD company. So there's a lot of focus on whether CBD hemp companies are making any claims related to COVID-19 specifically. We also saw another SEC suit against Curaleaf. So the SEC states that Curaleaf violated federal securities laws by making misleading marketing statements related to its CBD products. So when Curaleaf received a warning letter from the FDA regarding its products, its stock dropped a little over 7%, and the SEC argues that this harmed investors. So it's certainly another angle of liability that CBD companies will want to consider. All right, thank you for letting me go a little bit over time. I really appreciate it, and I'm open for questions if we still have time.
Sorry, had to unmute myself really quick there. So we would like to ask one question, and that's from your time in Washington, D.C. What lessons do you take from your time in D.C.?
So I think that on a technical level, it very much helped to have experience in telecom, because telecom and cannabis have conflicting federal, state, and local laws that all play into how companies in the space, must operate. And it's three fast-moving, tiers of rules and regulations. So having come from an environment where, that is simply what you have to navigate into another, where, the same rule applies, but things are still developing, that certainly helped me feel more comfortable. But I think it's also, just very helpful to understand how, disruptive business ideas and technologies are handled at the federal level and how that trickles down. I think that, the cannabis industry has so many different types of stakeholders, but really anybody who's operating in this industry is disruptive to some extent. So I think that, spending that time in DC, not only before regulators, but assisting with, congressional work has prepared me for a lot of the action that we're seeing now as, the industry starts to gear up for, federal legalization, or at least significant rules and regulations developing at the federal level.
Thank you so much for your participation in Canna World today and for sharing all of this very relevant information with the world. As we found, there are other countries that are a couple years behind the U.S., so lessons learned by us hopefully will ease their return of cannabis to commerce into their lives. So thank you, Elizabeth. We appreciate your participation today.
Thank you.